Uh, Good evening. Pleasure to be here on this ghastly Sydney winter's night. So I'm going to cover, I spoke to Kim earlier today and I said, well, where are we at, do you think, with knowledge of copyright? And she said, we'll have some people who know everything there is to know and more than you, Zoe, and then others who will be right at the beginning. So I'm working on the basis of the beginning through to more, and I apologise if it's too pedestrian for some, but it's always good to go over the basics, isn't it? I'm a lawyer at Copyright Agency. I've been there for about 9 years, and I've worked in copyright longer than that, having worked at the State Crown Solicitor's Office before then on copyright matters. I'm going to go through copyright. Of course, that covers all things digital. That's increasingly important for copyright owners. But sitting right alongside copyright, and I think extremely important, particularly online social networking, is moral rights. And I thought we had to cover that today if you're going to talk about copyright and online. And what is copyright? Well, it's a form of intellectual property protection. There's a whole family of rights in there. Copyright's one, trademarks another, patents another, resale royalty a very recent sibling to those, confidential information. Anyway, there's a whole package of things, copyright, one of them, the one we'll talk about tonight. And it's set out in the most fabulous legislation, a 700-page document called the Copyright Act of Australia 1968. In Australia, as in with most of our trading countries, Europe, Americas, the duration of copyright is the life of the author, and that includes, of course, an artist, plus 70 years. So that means once the artist has died, copyright subsists in any works they've created for 70 years after their death and goes to their estate. Copyright's not one single right, it's a whole bundle of rights. So it includes, for writers and artists, the right of publication, to put something in a book, to put it in a newspaper, to publish it on the website. The right of reproduction, to photocopy, to make digital copies. The right of communication, a very new right that's important for all of our social networking and web use. That right came into our Act in 2000. And in it is the idea of any travelling across an electronic path of content. So it means posting up to a website, to an internet, to an intranet. It means emailing material to parties. The adaptation right. Now that could be translation, it could be moving something from 2 dimensions to 3 dimensions, it could be moving something from one genre, say a novel, to a film script. And of course the performance right. If you've got a play script, the actual right to perform it. If you've got music, the right to perform. In Australia, as in most countries in the world, copyright is an automatic right. Absolutely no need to register with any government authority or anything like that. The requirement for copyright to subsist is that you create something original and that you record it in material form. So you either put it in, save it in a computer program, or you paint your canvas, or you type out your manuscript. As soon as you've done that, you have a copyright work. Another very important thing about copyright, there is no copyright in ideas. There is copyright in the original expression of ideas. What does this mean? It means if I go around talking to somebody about the fantastic novel I'm going to write, I describe the characters, I describe the structure, and I don't write it down, I have nothing, I have ideas. If somebody else takes my ideas and writes them down and creates a novel that is very successful, they have copyright in that work, not me, because they were the first person to express it originally in a material form. So, generally, under that beautiful Copyright Act, the first owner of copyright is the author or the artist. They are the person who will own that bundle of rights, and it's up to them how they deal with it. There are some very notable exceptions. Commissions are one. Typically, if I commission a work, then it is the commissioner who will own the rights in that work. Government, under our copyright law, enjoys very special privileges. Anything created under the direction or control of the Crown is owned by the Crown. So if you're doing any works with government, you should be very careful about that and look at any terms. There are very special rules for commissioned photographs, and this might be relevant to some of you. If photographs are commissioned for a commercial purpose, so say Copyright Agency has our AGM, and we get a photographer and say, please take photos for us, then we, brain slow, the photographer will retain copyright in those works. And if, however, it is for domestic or private purposes, that'll be a wedding, a significant birthday, or any other event that a person might have at home for a private use, then it will be the commissioner, so the family, who will own the copyright in those photographs that are taken. Other very important exception for a lot of us is contract of employment. I write some scintillating submissions on copyright law to government, and if a publisher came to me and said, we'd like to put together an anthology of your wonderful submissions, unfortunately, I don't own them, Copyright Agency does. And so for all of us, because most of us do some writing at our work, or we might take photos, or we might do other things, if it's a regular part of our contract of employment, then it is our employer who will own the works in those things. Employed journalists have some very specific rules that apply to them that are the result of industrial negotiation back in the late 90s. And it's a very basic split that is working out to be more and more not in the favour of journalists. Where there is hard copy use of works, so downstream use, so if you wanted to put together a collection of articles from a newspaper, or the New Yorker, which did cartoons from the New Yorker, if they're in hard copy, so if it's a publication or if it's a photocopying right, then it will be the journalist who has those rights. All digital rights are retained by newspaper proprietors. And of course, those are the rights that are gaining in importance and in dollar importance. Okay, important to know about these ownership rules. They are the default positions that exist in the Copyright Act. They can all be changed by contract and negotiation. So if you don't like the default positions, and if you have the bargaining position to do so, you can negotiate for other rules to apply. So if you're a very well-known writer and you're contracting with government to do something, then you can possibly say, I don't like the provisions in the Act about the government owning everything I do under their direction and control. I want to retain copyright in the report that I make or the work that I create. Same with employment. Some journalists, some of our top journalists around the country, will have arrangements with newspaper proprietors that say that they retain digital rights in their works for downstream uses. So all of these are subject to negotiation, but they are the default if you don't have a contract otherwise. If you're using third-party works, you have to make sure that you actually get permission to use those works. You should work out the specific purposes that you need them for reproduction, for communication on a website. You need to know that whoever you're negotiating with actually has the rights to grant you a permission. So I might be the artist of a work, but if I've created that under an employment contract somewhere else, and somebody comes along to me and says, Zoe, I'd like to use your photographs, no point talking to me. I don't own the copyright. You need to talk to my former employer. It's good to work out the time you need it for and to work out downstream uses. And what do I mean by downstream uses? It's that thing like, okay, I might be creating a book. What about if we want to post it up on a website? What about if somebody else asks to include it in a later anthology? So if you're creating a work using third-party works, think about downstream uses. Similarly, if you're the person being contacted by somebody, contemplate what those third-party uses are and how you would like to negotiate them. If you are an artist, it is always a very good idea to attach a copyright notice to your work. The first thing they will do is they will attribute the creator of the work and the copyright owner of the work. That's very good if anybody wants to do anything with that work, and it is also a reputational benefit so that people know a particular artist created this work. It will also explain to any third parties what they can and can't do with that work and who they need to contact if it's not covered by the copyright licence, or if the copyright licence says, if you want to do anything with this, get in touch with the copyright owner. If you enter into a licence, make sure it only covers the rights needed. If you're the person purchasing rights to use a work, all the rights that you get, including duration, time, different particular parts of the copyright right, they'll be reflected in the price you pay. So if you say, I want to use it for all time, for all purposes, then the licence fee you pay will be much higher, and probably higher than you need. Similarly, if you're the artist, you possibly don't want to give away rights to one party for all things, because you might want to do other things with it. So make sure that you're not entering into a thing that's a land grab of all rights. More on copyright notices. Most of you know that little symbol, the circle with a C inside it. That's a typical copyright notice. It usually has the author's name, the title of the work, might even have the year it's created. It's basically identifying information. It can be used to express the terms on which a thing can be used. For us at Copyright Agency, where we collect and distribute money where people have used works under collective licences we run, it's really important because it means that we can actually find the right rights owners and pay them. This copyright notice, at the start I said copyright's an automatic right. There's absolutely no obligation under the Copyright Act to use this copyright symbol and a copyright notice, but it's a very good idea. But if you don't do it for whatever reason, doesn't mean that copyright doesn't subsist in it and that people shouldn't be complying with the laws of copyright.